Hello, in this video we will explain to you what is a will and how it is regulated in Chilean legislation. First, and before we get started, it is important to know where the will comes from. A will arises from the notion of probate, which occurs when the testator, in his will, arranges for his property after his her death, as stated in Article 952 of the Civil Code. But what is a will? What is its legal definition? And in what regulation can it be found? The concept of will can be found in the Article 999 of the Civil Code, which explicitly states that a will is a solemn act in which a person arranges for all or a part of his or her property to have full effects past his living day, giving the faculty to revoke the clauses contained in it while still alive. Now that we know what it is mostly essential about a will, it is necessary we begin to know the subject more deeply. That's why now we want. What are the features of a will? First of all, the will is a unilateral legal act. That means that it constitutes a manifestation of will intended to create legal effect, and it is finalized with the sole intention of the testator. In second place, it is provided free of charge. This means that the assigning will acquire the assignment without any financial payment. The third feature states that it is a solemn act. This is that the Civil Code recognizes two types of will, both of them solemn, some because of their specialty they leave out certain formalities, but they don't cease being solemn because of that. In fourth place, the will is a legal act originated by death. In other words, death is the requirement for a will to take effect. Before that, a will exists, but it has no legal consequences. The fifth feature addresses that it is a personal act. It means that it is always and not carried out by a single person. It cannot be granted by attorney or a representative. In sixth place, it aims at providing an arrangement for the property regime of the one's death. And lastly, the will is essentially irreversible because it aims at depicting and ensuring the last will of the testator. Knowing already the concept of the future of a will, it is important now to check the several types of will, which we can classify in the following way. The first class or type is the open solemn will, non-occupied will. The Article 1008 provides for a type of will the content of which the testator may know the witnesses. The Article 1015 complements said definition, stating that what constitutes its essence is the act in which the testator makes its clauses known to the notary, if any, and the witnesses. The second type is the solemn. The Article 1008 final paragraph states that for such a will to be enforceable, it is not necessary for witnesses to be aware of its contents. Article 1023 complements the idea, stating that what complements its essence is that of the testator present a sealed instrument to a notary and to witnesses, declaring out loud that the content of said instrument is a will. The third classification corresponds to solemn will granted abroad, which can also be classified into solemn will issued abroad according to the rules of that country. Article 1027 states that the requirements for the will to be enforceable are to be solemn, to be in writing, to meet the formality of the country. Will granted abroad according to Chilean law. The Article 1028 states that for the will to be valid in Chile, it must meet certain requirements. For example, a person living a will must be Chilean or a foreigner with a permanent residency. The fourth type are the privileged will. According to Article 1008, privileged will are thus where some formality can be left out in consideration to special circumstances as determined by law. The fifth classification belongs to oral will. Is the one in which a person whose life is in an imminent danger that does not allow him to grant a solemn will can do it by declaring out loud so that everyone can hear and understand them, with at least 3 witnesses making its provision known publicly, so to say, which is regulated in Article 1041 and 1043 of the Civil Code. It is defined by doctrine as a will granted during wartime by the military and other individuals employed employed by troops of the Republic, volunteers, hostages, and prisoners that belong to said court, and to people who accompany and serve any of the above, provided they are part of war expedition currently underway or campaigning against the enemy, or a square garnishment currently under siege. The foundation for this privilege will lie in the fact that in war conditions it seems impossible to keep up with all the formality required by law. Finally, we find the maritime will, which according to legal doctrine author Samarriba is the one granted on a war Chilean vessel at open sea or an American vessel sailing under the Chilean flag. Up next, and to finish this subject, we will give you an important fact about probate in Chile. If while the purpose of probate is for the testator to arrange his property according to his free will, securing that way on behalf of the law the will of the testator. In Chile, there really isn't a free will to test, because legislators have opted to regulate the free disposition of property, stating that freedom to test only applies over a quarter of the sum of the testator, referred to as of free disposition, and not over all of the testator's property. In this sense, what legislators want to accomplish is to keep up in one side with the principle of free disposition of property, and on the other side with the protection of the man's heirs that will be left helpless come the death of the testator, if he decided not to consider them at the time he granted will.